Good morning, Mr. Wilkins.
Good morning, Madam Chief Justice, and may it please the Court. I represent Edward and Anna Fagan, who are landowners in Ipswich and the beneficiaries of an approval of their subdivision until this litigation. We have a number of issues here, including a variation on the case that was just argued, but I do suggest there's a common theme to all of them.
Mr. Wilkins, let me just ask a question that does not involve an issue that was briefed, but in this case, the board voted to rescind the approval.
Correct.
What happens to the 90-day clock after the board does something like that? Does a new 90-day clock start, or is the board required right then and there to either seek an agreement to extend? What happened? Nobody addresses it, but what happens?
Right. Well, in this case, it's a hypothetical, but I believe that the new 90-day clock should start. That would certainly be the import of the constructive approval provisions of the subdivision control law, and it certainly would be anomalous to have the board be able to rescind a constructive approval and then go ahead and having already missed the 90 days the first time, go beyond 90 days without consequence.
And they don't need to get an agreement, I take it.
An agreement to
An agreement with the developer to extend to get an extension.
To get the new 90 days?
Or 120.
Oh, I think they'd need an agreement to get 120, yes.
But not 90.
But why wouldn't it, if there was a final approval that the board then rescinds,
Yes.
why wouldn't the ball then be in the, I mean, there's an 8-year freeze, apparently, because it was endorsed, right? So why wouldn't the ball then be in the developer's court to file something new?
Well, that's what we did, and so that's why it's not an issue
And
here.
so it isn't an automatic 90 days, but it would start when the board, when the developer then files a new plan.
That's certainly a reasonable construction. That's what we did, and we have not argued the failure to decide within 90 days based on the rescission.
So there was not a final determination made within the next 90 days.
That's correct.
And there was no agreement to extend it.
That's correct. So that could be argued as well, but I think we only need one constructive approval here. And I suggest that in a number of issues we raised in our brief, the common theme here is that the lower courts have misunderstood what the subdivision control law is about. The subdivision control law sets up a dialogue between the landowner and the board, a dialogue with public input that allows the landowner to bring their plan in conformance with the board's regulations, whatever waivers may be granted, and generally to reach, it's a cooperative process. What the appeals court has done here is turn it into much more of an adversarial process with numerous pitfalls. And let me start with the zoning freeze. This case is a variation on the case that was just argued. In this case, there was a constructive approval on August 1, 2002, which was 90 days after filing the plan. 21 days after that, the abutters no longer had the right to appeal. And the one thing I would add to the arguments in the prior case is that the law is very clear that the constructive approval is final. That's the necessary prerequisite for an appeal. It's final 20 days after the constructive approval occurs.
So if the board had the authority to vote to rescind the constructive approval, it would have to have done it within 20 days after the date the constructive approval had occurred.
I don't think that's right. I think once the constructive approval happened, the board was powerless to do anything, and it was up to the abutters to appeal within 20 days or not.
But what about the cases that say that the board can rescind it?
The board can rescind it. It cannot. I don't think it can change its decision. It can rescind it even after the 20 days, which is what happened here. The way that the subdivision control law blunts the effect of a constructive approval is it gives the landowner on the one hand the benefit of the approval, but also gives the town the ability to rescind it. The question is, does the landowner then lose the benefit of the zoning freeze? Right. And it's not our fault that the board went more than 90 days. Why should the landowner be subject to losing the zoning freeze just because the board didn't do its job?
So the process, if the planning board can rescind the constructive approval, it sort of revives the process freeze.
Not,
I think
not until there's a filing, I would say.
Yeah, I think all freezes are still in effect, even despite rescission, because there was a final approval, a final appealable approval. that the abutters chose not to appeal. Now, the oddity of the appeals court's ruling in this case is that it invokes a rule that says, as between the developer and the planning board, a failure to file a decision will not affect constructive approval, where the developer goes on and talks to the board. And I suggest that's exactly contrary to the idea of a dialogue between the board and the developer. In this case, in fact, my clients did not appeal the board's decision in January of 2003. The board understood there was a constructive approval. That's why it rescinded. And my predecessor, my counsel at the zoning phase, tried to engage in negotiations with the board. That's also contemplated by the statute. The board can leave the approval in place, but place conditions on it. So this was exactly what my clients did, was exactly what the subdivision control law contemplates, a dialogue that it does not prejudice my clients' rights to the zoning freeze, but does result, hopefully, in some accommodation between the board, or not accommodation, but some agreement between the board and my clients, which is ultimately what happened after 16 hearings and a year and a half of process. There was plenty of process here. Now, my clients also have the benefit of an actual approval, not a constructive one. And that's the second part of the appeals court's decision. In December 4, 2003, the planning board approved of my client's proposal, which was basically just for 7 lots on 23.5 acres. Now, if we win this litigation, that will then become a final approval as well, and will result in grandfather protection. Now, the lower courts relied upon the appeals court's decision in Arenstam. And as we pointed out, that is a case that is distinguishable on the crucial points. It's distinguishable because in that case, there was never any approval, and here we have 2. Perhaps even more important than that, in Arenstam, the proposal that the applicant filed did not even comply with the prior zoning bylaw. So in that case, there was an ample reason to say, I'm sorry, you didn't file a compliant plan either with your preliminary plan or within 7 months after your preliminary plan. You never filed a compliant preliminary plan within the time frame, and therefore you're not entitled to a zoning freeze. In our case, our plan conformed to the zoning bylaw, the old zoning bylaw, when it was originally filed in May of 2003, and at subsequent times as well.
Mr. Wilkins, excuse me, in Allenstam, when they initially filed, were they seeking relief from some aspect of the then existing zoning, if you can remember?
Well, I'm not sure that I'm not sure they were clear about that. I mean,
Okay.
I don't know how one can file a subdivision plan that doesn't comply with the prior zoning bylaw. They later amended it to try to bring it into compliance, and that's the kind of amendment that the court said does not bring the freeze into play. And we're in agreement with that. An amendment that to a plan that was previously non-complying is no more complying than the original plan in terms of the zoning freeze. Now, in this case, it illustrates another point of contrast between this case and Arenstam. In our case, there were changes made to the plan after the board's original disapproval of the plan. That's exactly what the subdivision control law contemplates. And in fact, the statutory language of Section 81U refers to a plan as amended. In other words, a plan as amended to conform to the roadmap that the planning board gives when it initially denies the subdivision control law. I submit that such a plan as amended, in our case, the amendments were minor. We moved a couple of lot lines a little bit. We changed building envelopes and canopy restrictions, and we responded to comments that were made during the hearing regarding drainage and traffic. These are the kind of amendments that are contemplated by 81U. They're the kind of amendments that correspond to what Chapter 48, Section 6 talks about when it talks about an amended plan. And so this case, in contrast to Arenstam, illustrates the kinds of dialogue, the kinds of amendments, the kinds of process that are supposed to lead to the continuation of the zoning freeze.
Is the, what may or may not be dictum in Arenstam, is it in conflict with Chapter 48, Section 6, which seems to say that a definitive plan can be amended even after 7 months?
Well, yeah, I don't think it's in conflict. I think both our argument and Arenstam are correct.
But Aronstam seems to say that once the 7-month period passes from the date of the filing, you can never file an amendment.
Well, it's possible to read it that way, but I suggest that this court should not read it that way. Aronstam was not faced with that fact situation. It was faced with a situation of a non-compliant plan from the outset. What we have here is the contrasting situation, which sort of proves that Aronstam was correct on its facts. We have the contrasting situation where we had a compliant plan originally. We made modifications that were contemplated by the planning board, by the process that the legislature set up, and therefore, when 48 Section 6 talks about an amended plan filed after 7 months has to be an amended plan that is essentially the same with respect to zoning compliance. It has to be something that's amended in response to the planning board's comments, but not one that has a completely different relationship to the zoning bylaws. It has to be essentially a continuation of
tweaking the final plan that was filed within the 7 months.
Correct. And that's what Section 6 is referring to in terms of an amended plan. Now, I want to make sure I get to the waivers issue. There are a number of issues here.
Mullins issue?
Excuse me?
Is that the Mullins case?
No,
issue? I
this is.
would like you to get there, too.
All right. Well, I hope I can. The reason I wanted to stress the waiver issue is because what the appeals court did was kind of left my clients high and dry. There are ways to decide this case, one of which the appeals court did, where the waiver issue is not reached. Another way would be to say that these plaintiffs have no standing, which is another argument we make. But I urge the court to reach the question of waivers, because no matter what happens here, hopefully this is the end of the case and my clients can subdivide. But if they have to go back to the board is going to be faced with a superior court decision that struck down the waivers, and yet an appellate court decision, at least from the appeals court, that didn't reach that issue, but nevertheless found for the abutters. And what is the planning board supposed to do at that point? Does it have the power to grant waivers or not? The appeals court's decision means that the superior court's decision is no longer necessary to the results. So it's technically dictum. But I urge the court to reach the waiver issue.
One way or the other.
One way or the other. Yeah, I think we need to
Tell the planning board what to do.
The last thing we want is more litigation. We've had enough of that, and we need to have something we can tell the planning board as to where do we go. Now, the Mullen issue, let me address that because I had a question on it. I'll save the waiver issue to the brief. I will point out, though, that in this case, this design of this intersection is found to meet standards for a speed that is 7 miles above the speed limit, 7 miles above the speed limit. And as far as the drainage goes, the drainage will be reduced at all points off the property. And in fact, on the key road where the plaintiffs are concerned about, it will reduce the volume of flow by 22%. So there's a net benefit to a reduction of water on that road. Now, as far as Mullen goes, we take it one by one. The constructive approval.
But I thought that there was evidence that the wetland would increase. The wetland on Krafchuk's property, or I think it was Krafchuk's property, would increase as a result of the runoff from this proposed development.
No. The evidence was that there will be less runoff down Heartbreak Road. There still will be runoff. Her argument was that there won't be as much of a reduction as she thought the subdivision rules would require. I think she was concerned about, there was a general concern about water in this area and the fact that other development had caused increase in water, but it was never tied to this project. The experts agreed there will be less runoff to Heartbreak Road. Now, as far as Mullen, let me take this quickly. There's no Mullen issue with a constructive approval because there's no vote. The January 2003 vote was not a Mullen problem, first of all, because it was a nullity, and second of all, because, and this is, I think, the most important point, in the May 2003 decision of the planning board, that's the rescission decision. The planning board rescinded the prior disapproval, and it did it pursuant to a separately issued notice. The hearing was opened on one day. All members who voted were there on that day, and they adopted the original decision. Now, that's all you get for a Mullen case. You get another decision by the board pursuant to proper notice with everybody in attendance.
So you would sort of subdivide the decisions. Subdivide is a bad word in this case, but you would separate the decisions.
Well, I think the rescission decision was indisputably compliant with Mullen, and it washed out all previous errors. If the court had remanded the January decision, then the only remedy would be hold another hearing. Well, that's what they did anyway. And now if I may in the last 15 seconds get to the last hearing, which was in the decision in December of '03, there was no issue before the board that it had any discretion on, because my clients had complied with the roadmap that was given by the rescission decision, and the case law is clear that if you comply with that roadmap, the board can do nothing except approve it. Now, we have other arguments, but I see my time has expired.
Thank you, Mr. Wilkins. Mr. Gilbert?
Good morning, Your Honors. James Gilbert, and I represent the abutters who are the appellees in this matter. May it please the Court. We're here today to ask this Court to affirm the judgment of the Superior Court dated March 10, 2006, as affirmed by the Appeals Court. The factual issues that were found by Judge Welch, including the issue of standing, may only be overturned if this Court finds they are clearly erroneous. There's nothing in this appeal to support such a finding by this Court. I'd like to address the zoning freeze issue, if I may, first, and I'm happy to answer any questions on any of the other issues that may come up. In this appeal, the appellants seek to overturn the long-standing rule set forth by the Appeals Court in Amsterdam versus the Planning Board of Tingsboro. The facts of this case don't warrant such a departure from long-standing precedent. The appellants contend that the expiration of the 90-day period that's set forth in General Laws, Chapter 41, Section 81U, is self-actuating. Essentially, they want to ignore the plain language of Chapter 41, Section 81V, as it relates to constructive approval asserted under the provisions of 81U.
Well, but why should the clerk have this power to, in his or her discretion, say, I'm not doing it?
Well, I think that's an excellent question because it's not in the clerk's discretion. That language in 81B is very clear. It says the clerk shall issue.
And the clerk, in fact, in this case, did, in a way, right?
The clerk never issued until 3 days before trial a certificate that the Superior Court found was not timely and certainly was 3 years after the
So you
Krafchuk
say that these
report.
plaintiffs, as in the prior case, are out of luck because they didn't move for mandamus after August of 2003?
It wasn't in this particular case. The facts are a little bit different because the developer never requested the certificate, so there was no refusal by the town clerk to issue it. The developer never went to the town clerk to get a certificate. No certificate was sought, and so as a result of that, we ended up in a situation where if a constructive approval that occurred under 81U never became final because that certificate never issued, never sought by the developer, never issued by the town clerk. But it wasn't an issue of the town clerk refusing to issue the certificate. And the reason why I make that distinction is it is pretty clear under 81V that the clerk it's not a discretionary act by the town clerk. That is the language of the legislature, is that the clerk shall issue the certificate.
But in this case, am I correct that the board, I'm going to probably get the month wrong, but maybe May, was it, the rescission decision?
I'm sorry,
The planning board voted in May, the rescission
May
decision?
2003.
May
That's correct,
2003?
to rescind constructive approval.
Right, so my point is simply that the planning board thought that there was constructive approval, right?
Oh, I don't think there's a distinction between constructive approval having occurred and whether a constructive approval becomes final. A constructive approval under Section 81U occurs after 90 days.
Right?
Once you have that constructive approval, you can then get the certificate from the town clerk after the expiration of the 20-day appeal period. No certificate was ever sought or obtained in this matter. So what happened was, because there was no final approval sought under 81V, and by the way, the developer withheld an assertion of constructive approval until after the January 2003 decision, which denied the subdivision. There was a denial of this subdivision by the planning board in January 2003. After that denial, the developer then asserted constructive approval. Once the assertion of constructive approval came through, the board was faced with a decision as to whether to rescind that constructive approval that occurred. The board made the decision in May of 2003 to rescind the constructive approval and then reinstate its January 8, 2003 decision denying the subdivision. So what you end up with is a 90-day period passes, no certificate issues. You have a denial then by the board because the developer agreed to continue the hearings. You have a denial in January 2003 by the board on the subdivision. You have followed that with an assertion of a constructive approval, followed by a rescission of constructive approval and a reinstatement of the decision of the planning board, which was to deny the subdivision.
How long does a board have to rescind constructive approval? Is it within normally within 20 days after the 90-day period has lapsed?
There is nothing in the statute that I read that requires the board to act within a certain period of time to rescind constructive approval. So, in other words, if a constructive approval occurs, they can rescind it at any
So
point in time.
if 20 days has the 20-day appeal period passes and a mandamus action is commenced, the mandamus action hangs around in Superior Court for 6 months, gets ready for trial, the planning board can vote to rescind constructive approval?
Well, it can, because if you look at the language in, I believe it's 81W that deals with the rescission of constructive approval, they talk about how buyers in good faith, if they purchase a lot on a subdivision that has already been constructively approved, that they cannot, those lots are still valid, even though the subdivision may eventually be rescinded as a result of constructive approval. So I think the legislature anticipates at some point in time in the future, based on a constructive approval, there could be a rescission of that constructive approval, even after these lots have been marketed.
Mr. Gilbert, what do you make of Mr. Wilkins's argument that Allenstam should be limited to its facts, namely that the initial plan was not in conformity with the then zoning requirements?
Well, I think that's an incorrect reading of Aronstam. I think what Aronstam was stating was that this is not an open-ended process that's contemplated by the legislature, that once the preliminary plan is filed in advance of the zoning change, and then the zoning change occurs, the concept is that the developer, the onus is on the developer to work with the planning board to get a finally approved plan within the 7-month period, that the process freeze remains in place.
Do you read Aronstam to prohibit any modifications after 7 months, even if they've been recommended by the planning board?
I think we're in a situation where, if that were the facts, and that's not necessarily the facts of this case, if that were the facts of the case, that may be something that would be argued later. I would argue that Aronstam does not allow an amendment following that 7-month period. In other words, what Aronstam tried to do was put closure with a definitive period of time on which to act on prior existing zoning. You have to allow the towns, if they've moved forward properly and made a zoning change, to have those zoning changes take effect. If a developer gets in this case the developer filed just 2 days before the zoning change was to occur, filed his preliminary plan, what Aronstam says is you have to move in a timely manner, because we cannot freeze zoning forever if you're going to take forever to get through the process.
But the legislature has said you've got 90 days to do it.
I'm sorry?
The legislature has already imposed that. They said that we're going to move this along by allowing constructive approval within 90 days of the filing of a definitive plan. Isn't that the end of the process?
Well, it's not the end of the process. It would be the end of the process if we were to rescind 81B entirely and just say 81B has no particular purpose. But if you look at the kind of interaction between the statutes here that we're dealing with, and this has been brought up in the earlier argument, 48 Section 6 talks about final approval. That's the words used in 48 Section 6 as to when the 8-year freeze kicks in. You go to 81V, it talks about final approval. The certificate is issued as evidence of a final approval. In this case, it would be issued as evidence of a final approval by means of constructive approval. If you go to 81U, you don't see the words final approval. You simply see the word approval in 81U. So the real question comes down, I think, that's before this court, is whether or not constructive approval under Section 81U is self-actuating. In other words, does it just occur upon the occurrence of 90 days without any further action by anyone? And if that's the case, what's the purpose of 81V?
Well,
If we're going to have it self-actuating, it wouldn't seem to make much sense to have any certificate under 81V ever.
But in this case, after the argument that there was a constructive approval and then the rescission, and then ultimately you get a decision by the planning board approving the subdivision control, the subdivision plan, right?
In this case, it was an approval of an amended plan that was filed in October of 2003, following 2 denials of the plan.
But I take it the amendments were in response to comments by the planning board. This wasn't just a whole new plan.
Well, this is a very unusual situation. The decisions of the planning board that were issued, both the January decision and then the decision again in May, which adopted the January decision, actually set forth, and this is why we appealed. We're in the very unusual position of abutters of appealing a denial of a subdivision. What happened was that the planning board actually issued a decision denying the subdivision and then setting forth an approval of about 23 waivers of its rules and regulations within the context of a denial of a subdivision.
But the statute provides for that.
The statute provides for them to give basically reasons for the denial.
Yeah, and
It doesn't
isn't that
say
what
go ahead
happened?
and approve waivers in your decision when you're going to deny it. I mean, it doesn't make any sense. And it places the abutters in the weird position of having to appeal a denial, which is what the abutters would seek to begin with. In this case, we did it because we felt we had to preserve our rights to challenge those waivers in the decision, and we were afraid if we didn't do that, we might be having held as waived our right to challenge the waivers in the denial of the subdivision. So part of this, we believe, is because the planning board erred in its interpretation of the statute. And that's caused part of the confusion here.
Why was the Superior Court judge right in saying that there was no basis to grant the waivers?
Well, the judge heard expert testimony, and we had two experts come in, one for the developer and one for the abutters, and took extensive testimony. We had over some 100-some-odd exhibits and 4 days of trial on this. And the hearing that we hear on a subdivision control case is de novo. So the judge was hearing the evidence, he was listening to the evidence, he was evaluating the evidence and evaluating the experts. And what he heard from the experts was that the design of this subdivision was faulty, that there were mistakes made in the design of this subdivision that caused very serious questions about the actual safety of the intersection of Heartbreak Road and Blue Spruce Drive, which is the proposed new intersection. And he went into specifics on some of the drainage issues that had to do with that, as well as site distance and so forth. It's proper for the Superior Court in a de novo proceeding to take that evidence and to hear that evidence and to make a determination. And the Superior Court's job at that point is to determine whether or not the board exceeded its authority in the issuance of, in this case, the waivers for certain drainage issues and certain safety issues surrounding the intersection, and he so found that they did exceed their authority.
Thank you, Mr. Gilbert.
May I proceed, or are we done?
I'm sorry?
I have a few more minutes. Do you want to?
No, if you don't, I thought you had finished your argument.
Oh, no, I was just going to address the Mullen issue, if I
Oh,
could.
you can do that. You can use your time. I was giving you, when you didn't talk, I thought you were finished.
Oh, I was just waiting for a question. I'm getting used to getting questions here. I did want to address the Mullen issue because we
Okay.
did have a very serious matter in this case. There was a lot of factual matters that were presented to the planning board, lots of expert testimony that went before the planning board, and these hearings went on, as you can see in the record, for quite some time.
Well, could
During-
you address Mr. Wilkins's theory that they were divided into different votes and different segments of the issue?
Well, this takes us right back to the waivers again, because the situation here is when you're sitting in an adjudicatory proceeding, if you're going to vote on something, whether it's a waiver or whatever, you've got to be present to hear the evidence. What happens if we adopt my opponent's interpretation of the statute is that you don't even need to be present to hear the evidence in an adjudicatory proceeding in order to make a determination.
But if you have changes in the board and you have a case like this where the hearings go on ad infinitum, do you have to keep starting over again? Is that your point?
Yes. And
Well, isn't
let
that
me
a
explain
little
why
wasteful?
that's. But let me explain why that's important. In a case like this, we had expert testimony dealing with very specific issues, and the failure of a planning board member to be present for that places them in a situation where they do not have the requisite knowledge to vote on the waivers they're being asked to vote on. These are very serious issues. These are very serious problems that are coming up. And in this particular case, one of the things that was focused on was the flooding of the intersection, and we went into a lot of detail on that. As soon as we move forward, and again, this was dragged out over a significant period of time, but as soon as we move forward on that issue, we end up with members of the planning board who have no knowledge of these issues. And when we sought to bring them back again before the board denied the abutters the right to even raise these issues at the subsequent public hearings. So in an instance where
Mr. Gilbert, I'm sure you recognize what the problem for the court is, because town board, planning boards, these are, I assume, volunteer boards. People come and go. I mean,
That's
it
correct.
can't be, these are costly proceedings. They're costly to experts. They're costly to counter-experts. I mean, it can't be that every time, I don't know what the solution is, but it can't be that you have to go right back and start at the beginning, surely.
Well, I would argue the solution is constructive approval. In other words, you have things in place so that make sure that these things proceed orderly, in an orderly basis. In this particular case, there could have been an assertion of constructive approval after 90 days that would have stopped this. Process had the developer gone and got the certificate under 81V, and that would have been the end of the process. In this particular case, the developer chose not to do that, chose to move forward with these lengthy hearings. That was the developer's option. That was the developer's choice to move forward. But it doesn't mean that the Mullen Rule should not be in effect simply because the developer chose to take that avenue, as opposed to having asserted constructive approval in a timely manner, which is the developer's option here. So there is a solution to this Mullen concern, and that is the constructive approval under 81U.
Do you have any of our prior cases that would be authority for your position?
With respect to
This starting over when new members are appointed?
no, I think the Mullen Rule is an appellate level decision. I'm not sure that we've had any of that. The only thing I will state is when the legislature took a look at this in 2006 under I believe it's Chapter 79 of the Acts of 2006, they took a look at the Mullen Rule. And what they decided was that a planning board member could miss only one meeting. Only one meeting. That was the change made to the statute as a result of the Mullen Rule. And that if a planning board member misses one meeting, they have to file an affidavit stating that they have either reviewed a transcript or reviewed the tape recording of that meeting, and file an affidavit in order to be able to vote. So the legislature has already looked at the Mullen Rule, decided the Mullen Rule makes sense, and amended it only to allow a planning board member to miss one meeting.
You're saying that the legislature in 2006 was reacting to Mullen, which was decided in 1983?
I actually think the legislature may have been reacting to one of these cases that you're hearing today. There was a lot of pressure from Mass Municipal Association for the legislature to take a look at the Mullen Rule. The legislature did, in fact, do that. They had hearings, and their solution to the Mullen Rule issue was Chapter 79 of the Acts of 2006, and I think that's instructive to this Court that the Mullen Rule was, in fact, endorsed by the legislature.
But in protracted proceedings, which can occur, if, for instance, the waivers had been granted early on in the stage before the definitive plan were filed, and then the personnel of the board changed because you have a new year, people were either voted in or appointed after a term lapsed. Are you saying that the next board would have to go back and revisit the question of waivers?
Not on the preliminary plan, but in the, I think you said before the definitive plan was filed.
Yeah, they were granted in anticipation that they would be included in the definitive plan.
I think when they come back on the definitive plan, if you've got a change in membership, you've got to go back and address the specifics of those waivers. But the solution is not that difficult, because what you can do is come back in and discuss those waivers in a public hearing before the new board, so that the new board member has the benefit and knowledge of those waivers. It's not quite as onerous as it
discuss,
appears.
but you say discuss. Does discuss mean bringing back the experts?
It would obviously, Your Honor, it would depend on whether or not the issue required experts. But assuming it required experts, I think the assumption is the developer would bring
Well,
the
here
experts
you had
back.
experts, right?
Yes. And I think the developer would be required to bring back the experts.
Thank you, Mr. Gilbert.